Well, we're still waiting for people to come in. Well, I think we should get started. Welcome to everybody. It's Monday, 13 December, 8 p.m. in Bonn, in Germany. It's Tuesday, 14 December in Sydney, Australia, 6 a.m. We are live, and you see we try everything to bridge the world, to bridge time, in order to invite you to the ICN Spotlight, the fastest format in the framework of the ICN. It's 45 minutes of an interview with someone in the competition world who has something to say. And today I'm very, very happy that Rod Sims is with me. Rod is the legendary chairman of the legendary ACCC, the Australia Competition and Consumer Commission. The ACCC is a pillar to the International Competition Network, to the ICN. It is a working group co-chair. It is a member of the ICN steering group, and it has been the host of the ICN annual conference in 2015 in Sydney. Rod Sims himself is a pillar of the ACCC and the ICN. Rod is the vice chair in the ICN for digital coordination and Asia Pacific liaison. Rod has been the chair of the ACCC since 2011. He has been reappointed twice, thus becoming the longest serving chair of the ACCC. Our topic today is competition enforcement in the digital economy. That is an important topic. We all know that, subject to many conferences around the world, subject to many cases, subject to legislation around the world. The ICN took that topic up early on one can say the start was the 2015 annual ICN conference in Sydney. The ACCC itself is extremely active in this topic. It is very, very advanced. From my perspective, a bit in the driver's seat for the time being with regard to this topic. So Rod, great you're with us today. Many thanks for joining us here in this ICN Spotlight.
Thanks very much, Andreas, and thanks for those very kind comments. And it's just a great opportunity to talk to people around the world, as you say. And as we were just discussing earlier, I'd much rather 6 a.m. in the morning than midnight. So this is a great timing. Thank you for accommodating it.
Yeah, thanks for being with us. I'm happy, by the way, not to be in your skin right now. Rod, the digital economy is somewhat different than other parts of the economy. It has different features. The mechanisms are different. It works completely different. So when you tackle big tech, when you tackle the digital economy, you must find your own approach. So can you tell us what has been the approach of the ACCC in tackling these questions and in tackling big tech and digital platforms?
Thanks, Andreas. Yes, I think in essence, our approach has been to start with a detailed market inquiry, market study. We had an 18-month-long inquiry. It had a very wide terms of reference given to us from the government. The importance of the government giving us the the terms of reference and the inquiries. That unlocks our information gathering powers without the government directing us to do it. If it's self-initiated, we don't have the information gathering powers. So that was very important. But it was also a very broad inquiry. It covered competition, consumer. When you deal with consumer, you do drift into privacy issues. It also was asked to look at advertising, which of course brings in data issues. And it was asked to look at the news media, the situation that the news media businesses find themselves in. That breadth allowed us to spend a lot of time understanding the market power that the platforms have in messaging, search, apps, ad tech, understand the significance of that market power. So I think, Andreas, what I find interesting is when you're doing an investigation to see whether there's a breach of the Act, you're necessarily seeking evidence to that end. And so there's things you can put into a courtroom, because we have a prosecutorial system in Australia. So you're looking for what evidence goes into the courtroom. You're not actually looking in a wider sense to solve the problem. And so we were able to go in all sorts of directions with a very wide terms of reference to get a deep understanding. To cut a long story short, we made a lot of recommendations on competition issues, consumer, data, privacy, news media. I'm pleased to say the government picked up virtually all of those, so that, for example, we've got a review of the Privacy Act in Australia, wide-ranging review. We've got issues around disinformation, misinformation being dealt with by another regulator, news media bargaining code, but also competition and consumer recommendations. So just to finish up, out of this inquiry, we identified 6 investigations, 4 breaches of the Act. We've taken 3 cases to court. Only one's been decided, and we won that, where Google was saying to people, if you switch off location, you won't be tracked, when in fact, you not only had to switch off location, but switch off something else you couldn't really readily see. So I guess the essence of the approach is just get a deep understanding of the broader issues rather than, I think, the narrower approach of taking cases. But we've done a bit of that as well.
But to make that a bit practical for other agencies around the world, that was a very broad inquiry, if I got it right. So if you do something like that, how many people are sitting on such a project, and how long does it take? Because I have the experience here in the Federal Cartel Office, when we do sector inquiries, we always start with lots of people, and we want to do it as fast as we can. And then we find other things come in, mergers come in, other things come in, and then it lasts and it lasts. So what is your clue to this? How did you manage that?
So what happens in Australia, Andreas, is when the government gives us an inquiry, it not only gives us a terms of reference, and this was a broad one, and of course we strongly shaped that terms of reference. We engaged with the government very early. We sought the inquiry. We weren't just a passive recipient, I ended up talking to ministers, parliamentarians.
Yeah.
It not only unlocks the information gathering powers, but they gave us the money to do it, Andreas. And so that was crucial. So of course, immediately we draw in people that we've already got in the organisation. So there's that short-term cost, but because they give us the money, we can recruit back in to fill those positions. So yes, it is a drain on the rest of the organisation, but because we had dedicated money,
yeah,
you had to use that to see it through. So we had about, going back in time now, Andreas, but I think we had about 14 or 15 people full-time on this. And of course, they can draw on our lawyers, our economists, our data experts, who all reside in different areas. We met once a fortnight as a subgroup of our commission, myself and 2 other commissioners. So it was extremely intensive for myself and the other commissioners. But yeah, we got the money from the government, Andreas. That's the key point, which meant those resources were dedicated. We could backfill.
Yeah, happy Australia, I can only say. Rod, you mentioned already the news media bargaining code. We here over here in Europe, we're just about to implement the new European copyright directive with ancillary copyright and everything. With regard to the amendment of the German competition law, there's a small passage which also says something about the relationship maybe between the publishers and big tech. So the aim here in Germany is to have a fair relationship between big tech on the one side and the publishers on the other side. So from my perspective, Australia also was here on the forefront with legislation, and that legislation seemed to be followed by threats by big tech to shut down certain areas of the network if this was really coming into place. So if you looked at German newspapers during that time, there were lots of reports about Australia. And there was the question, what is more important in Australia? Who's sitting in the board of big tech or who's sitting in the board of the government as a minister? So for us, that was an exciting time. And we look a bit to Australia right now because there's similar problems, of course, over here in Germany. So what was your approach to media and digital platform issues? Your new legislation, and can you tell me how it differs from the European approach?
Yes, thanks, Andreas. So we looked at thinking about a copyright approach, which is what you've done in the UK. But our copyright laws are complex, firstly. Secondly, it was just a messy situation to get into where it was hard to see how you work that through. Secondly, how do you actually price it? How do you know what the price for the copyright is?
Absolutely.
So we approach this not as a copyright issue, but as an imbalance in bargaining power issue. Now, we see this all the time in Australia, as I'm sure you do in other countries, but we have many privately owned rail tracks, ports, gas pipelines, electricity networks, and not to mention in the early days, a privately owned company owning the copper wire, which you need to be in, which is at that time, the only way you could connect to homes for telecommunication services. These traditionally in Australia have been approached as imbalance in bargaining power. Now, of course, there's imbalances in bargaining power all throughout the economy. But here, that imbalance was profound. Even our largest news media businesses could not have any commercial negotiation with Google and Facebook. What we found, by the way, in the study was that Google and Facebook do have market power in relation to news media businesses. So Google and Facebook really do need news businesses, but they don't need any individual news business. Whereas each individual news business needs Facebook and Google. So that imbalance meant that when the media businesses tried to negotiate, they got nowhere. We could see that. Even the biggest of our agencies got news media businesses, and we've got 3 big ones, possibly 4, depending how you want to count it. They could not get anywhere. So that imbalance leads to a market failure because basically Google and Facebook were using the news media content without paying for it, which meant a lot of effort from journalists was getting out to the community, but not being paid for. So you had news media businesses closing down, you had not enough journalists being employed, some areas of journalism not being looked at. And journalism is just fundamental to society. So not all market failures matter, but this one mattered a lot because it was essentially undermining journalism and therefore society. So what we did was say, well, rather than copyright, let's force people to bargain. And if you can't succeed in that, then it goes to arbitration. So it's a negotiate, arbitrate model. The beauty of that is if you're forced into arbitration, usually you will reach a commercial deal to avoid that, because a commercial deal is much better done than an arbitrator deciding the outcome for you. But the ability of the weaker party, here the news media businesses, to go to arbitration meant they had some muscle in their arms that they could not be ignored. You had to sit down and negotiate, otherwise you'd end up in arbitration. So it's a very successful model. And in this case, I mean, as the legislation was getting debated, as you correctly said, Andreas, we had Google threatening to leave Australia so that there would be no more Google search. What was interesting about that is within days, Microsoft was there saying, well, Bing can take over. So, you know, we'll talk to the government, we'll talk to the Prime Minister about Bing.
Rod, they're just the two of us now. Was that a serious threat from your perspective, or was that part of a negotiating?
Look, it was a serious threat, Andreas. And well, let me just mention Facebook and then I'll come back. It's a question. So Facebook said, well, if rather than, see the negotiate arbitrate model is not a must carry. The way it was set up is if you show if you show any news at all, news media, you know, journalist articles at all, then you have to negotiate with everybody. But you can choose not to show any journalism, any news, and then you don't have to do it. So Facebook said, all right. So Google threatened just to leave the country. Facebook said, well, we won't show any news. And then one morning I woke up to find that they had taken all news off their platform. Also, they'd taken all emergency services, and this was at the time of COVID. So they really overplayed their hand. So I think, Andreas, this became an issue of extreme importance to Google and Facebook, like it was for the government and news media. And they did not want to be designated under this act. They did not want to pay for news articles in search and news articles on your Facebook newsfeed. And I think the threats were serious. I can't know where they would draw the line, but I've been involved, one of my earlier career times, Andreas, was negotiating mining and petroleum agreements all around the world. And so I've done a lot of negotiations. And when it matters, you know, when there's high stakes, you usually do get threats, you do get walkouts, but eventually if you can find something that matters more to the other side than it matters to you, you reach a deal. And that's what happened here. So such a high stakes game, Andreas, was always, in my view, going to, it was inevitable that the sort of threats that were made were always going to be made. I didn't know whether they'd carry them through, but I knew that they'd make them.
I mean, that is really fascinating. I mean, we have all learned never threat with anything that you do not want to make true, because you lose credibility immediately. This is why I can think that it was a serious threat. At which stage is this now, Rod? Is this all said and done, or are you still struggling in a way? At which stage are you exactly with that piece?
It's been very successful, Andreas. So implicitly, the deal that was done was, I mean, there were certain concessions around the legislation made to both Google and Facebook, things that didn't much matter to the government or the ACCC, but mattered a lot to Facebook and Google. But the other thing that was said was, we will designate you under the Act, that is, designate Google search and designate Facebook newsfeed, unless a lot of deals are done. So given that Facebook and Google did not want to be designated because of the international precedent they thought that would allow, they have done deals to avoid even being designated under the code. So what we've now got is deals done with our 3 or 4 largest media businesses, virtually all of our medium businesses. Facebook hasn't done deals with 1 or 2 of those, but most of them. and a hell of a lot of small businesses. So contrary to the misrepresentation you see overseas, most of our small media, certainly all the ones I could think of going into this, have got deals. There's some very small that haven't, but basically large, medium and small. They've got deals. They're happy with them. More journalists are getting employed. We don't know the final numbers, Andreas, but my guess is there's north of more than $200 million a year being paid, perhaps a lot more. I don't really know. The key thing about these deals, Andreas, is they were never meant to be published. It was evening up the bargaining power so that you had a deal that the news media businesses were happy with, and they're all happy with the deals they've got. So it's been tremendously successful. There's still, I think, a couple more deals to be done, and there's going to be a review of the News Media Bargaining Code in March next year. But in essence, the vast bulk of Australian media have got 2, 3, 4, 5-year deals. It's been extremely successful.
This is so fascinating, Rod, I must say. The amount of money that is paid, that would be my last question. You said you don't know it, but if you knew it, you wouldn't publish it, I guess. It's a business secret, I guess. So, because it could be a model for the whole world in a way, because everyone is trying to figure out the right figures. How much do they have to pay? And
yeah. Well, we left to the parties to determine that, Andreas, and I kept in touch with most of the media businesses, and when deals were done, they were happy with the deals. It wasn't just the money, it was the nature of the deals they had to provide. And again, much better that you do it commercially than you have it imposed by a regulator or an arbitrator, because they did deals that suited each other. But there's no doubt, I heard from numerous chief executives of media businesses, they were very happy with the deals that were done.
This is
and I should add, Andreas, sorry, we've had recent, I think at the OECD meeting a couple of weeks ago, someone from Australia who knew a very experienced, seasoned Australian journalist quoted that journalist as saying, there's never been a better time to be a journalist. There's jobs going everywhere.
That's great.
So I think that's another testament to the success.
Great. Well, this is where we still need to get, Rod, let's turn to another area, maybe. You put out 3 further reports in 2021. I mean, there everyone can see how active you have been in the ACCC. That was on ad tech, on search and apps. So all main areas of big tech. To be frank, all these kind of areas where you think you need some, well, neutrality, in fact, of the companies at stake. So, in general, what was your impression from these three reports, and how did it shape your kind of thinking about this sector? Because we are just about to finish our report on AdTech in Germany, and I mean, I took a look at it, and I can already see this is, at least in parts, changing the way I look at this sector, and it is extremely interesting. So how did it shape your kind of thinking when it was published and when you looked at it?
Yeah, thanks, Andreas. So we had a quick look at these a fairly detailed look at these sectors in our first major inquiry, but then we did detailed, deep dives into ad tech, search and apps, as you say. And obviously, just to step back, I mean, when you think of search, apps, ad tech, we also did a previous one on messaging services. I mean, this is the internet. This sort of is the future of the world. Yeah. I mean, in Australia, most people are going to be watching television over an app. So just, that they are crucial markets. And what we found was, at one level, conflicts of interest, obviously Google paying, Google has got 94% of the search market in Australia. They pay enormous sums of money to Apple and other OEMs to be the default search engine. And of course, they own Android, so they are the default on the Android devices. You've got a range of self-preferencing. When you look at the sectors, search, apps, ad tech, what I think strikes you is just the massive degree of market power, which is just unquestioned. I always get a bit amused when the parties say they don't have market power. Well, of course they do. You're 95% of search. If you want to be an app on a mobile device, it's got to be Apple or Google. You've only got two choices. Ad tech, Google, there's four parts of the value chain. Google has 60 to 90% of each part of that value chain. And the next biggest player is just miles away. So they've got tremendous market power. But what I think really comes across, Andreas, is using our traditional enforcement tools is not going to solve the problem. I mean, we need competition in each of these sectors. If I could just, pardon me for 1 second, but one of my favorite lines is saying, when you think of Adam Smith, who wrote 250 years ago and wrote the book that's the foundation of a fair bit of economics, his most famous line is, it's not from the benevolence of the butcher and baker and the rest of it that you get your daily meal, it's from their regard to their own self-interest. So that just explained the market economy. But what he meant by that is you need competition. If there's no competition, the bread's going to cost you a fortune. It's not going to taste very good, and so on. So what Adam Smith told us all is market economies need competition. And if we don't have competition in all of these sectors that are so fundamental to us, then our market economy, our innovation is going to suffer. So what we found is we looked at the ad tech market, and Andreas, there's 5 or 6 competition cases you could take in ad tech, probably more. But each one of them would take a long time. Each one of them, to win them in court, you'd have to narrow down the issues and say, you did, precisely this. But if you stop them doing precisely this, there's a whole range of other ways they can still dominate. So what I think it showed us, and we've got some competition enforcement investigations underway to see whether there's breaches we can put before the courts. But what it really showed us is, if you want to have competition in these fundamentally important sectors, you need upfront, ex ante, pro-competition rules to set the platform. I mean, you've got them in Germany. They're on the way in Europe, the UK, talk of them in different ways in the US. And of course, we're going to be looking at that very issue about what are the rules that are needed in 2022. That's going to be our consuming focus. But I think the key takeaway is 3 or 4 cases in ad tech won't solve the problem. You need the upfront rules.
Yeah. We all know, Rod, that a big part of our work is advocacy for competition, which also means that we have to explain our work. Why are we doing this? And if I talk to consumers, sometimes you have people who say, well, why do you care for all that? It works so well. We don't pay for it. We get an excellent service. There's really people wondering, why are you so active in this area? So how would you explain that? Why is it so necessary that we do maybe even more in big tech, in the digital economy?
It is the right question, Andreas, and I would explain it as follows. Firstly, with these small number of companies dominating these fundamentally important sectors, at the highest level, they are the ones controlling all the innovation. So that's one sense. We're tying our innovation to a small number of companies. From a consumer perspective, we did surveys, Andreas, and we said to people, if you were tracked around the internet in this sort of way, what would you think? And 85 to 90% said, oh, that'd be outrageous. Can't do that. That's exactly what's happening. So I think consumers don't have a good understanding of what's going on. They don't understand the price they're paying with their data. But more importantly, they don't have choice in the business system. And if I could just look at Google search, because Google dominates with the default payments, it is the default search engine. You don't have business models such as DuckDuckGo, which its business model is based around privacy. You won't get tracked. When people have that explained to them, then many of them move to that. And the difference between the DuckDuckGo search engine and the Google search engine is only at the extremes. It's not the core search that you do. And of course, the other thing with search is the more it's dominated by one player, the more that what you see is what has been paid for, right? The original organic search that looked around to see what was best for you, now you're seeing what is paid for. So you're not getting what you thought you were getting before. When it comes to apps, innovation on apps, the type of apps you can get is controlled by two players.
Yeah.
So you're just not getting the range of choice that you want out of this fantastic internet. So yes, Apple, Google, Facebook have ridden the wave. They've given us fantastic innovation, but what you're going to get out of it, your ability to use it is going to diminish in value unless we get more competition to keep the pro-consumer innovation going. I'm not sure I've convinced all the consumers out there, Andreas, but this is all about consumer choice, consumer experience, and whether consumers, I mean, the harms of, you could easily see dynamic pricing. The pricing that you're offered for a product that you see depends on where you live and your past experiences in shopping. You're really putting yourself in the hands of a very small number of companies, and it will mean less privacy. It will mean higher prices. It will mean less choice of different sorts of products around the internet. If you're a user of the internet, you want the maximum choice you can get. Your choices are narrowing, not broadening.
Yeah. I mean, this is exactly in line with what the Federal Supreme Court here in Germany said on our Facebook case. It said that Facebook is a dominant company with regard to social networks. It said that Facebook is abusing its dominance by forcing people into a limitless collection of their data, and that it does not leave the consumer any choice whether he wants to do that or not to do that. And I think that is the key issue we need to talk about, is to open these area for choice, that consumers really have a choice. And maybe a second comment on what you said. I fully agree that innovation is key. And the problem is that innovation that does not take place, well, you don't know about it. You do not know what is possible and feasible in this world. So any company that is dominant and that is abusing its dominant position may easily say, oh, well, listen, I'm so innovative, but you have no idea if there would be room for a new entrant, maybe this world could be much more innovative, and you don't know about it. So I fully agree. Rod, for us, you're fascinatingly far away, just once around the globe. And there's so much going on, not only in Australia, but I think you have an excellent perspective. What else is going on? We all hear about Korea, that they are very active. We hear about the Japan Fair Trade Commission, that there's lots going on. Can you tell a little bit about your exchange with these agencies and what they are doing in this respect? Because this is a worldwide movement. It's not limited to the US, to Europe and other areas. There's so much going on in your area.
There is, Andreas, and various agencies throughout the region, Malaysia, Singapore as well, are doing market studies and really looking at this and participating in forums. I participated in an ASEAN forum about a week and a half ago, talking about just these issues in more or less just this way. But the interesting thing with those two countries you mentioned, I mean, Korea has just passed a law that says that Apple and Google can't insist that you use their payment platform for in-app purchases. And let's just understand what's going on in apps. So in apps, if you're an app and someone wants to pay for something, they have to do it through Apple Pay. They pay a 30%, in the case of the major apps, fee to Apple for doing that. But they can't even, the app can't even tell its users that actually, if you go to our website, you can get on and buy the service for free, or for a lower amount without the 30%. They're even limited in what the apps can say to their users. Apple is controlling that and forcing them to use Apple Pay. Korea has just said you can't do that. You have to give the app the choice of payments through other than Apple Pay. Now, that is a profoundly important law. To get that outcome through a court case would take a very long time, and you still may not be able to do it. But it is essentially tying. That is, Apple has the App Store, and it's tying you to its payment mechanism. And while such tying arrangements are okay when a company is small, when Apple, which is 50% of the mobile market in Australia, then that means that you're using your leverage in the phone market, the App Store market, to leverage into the payment market. And Korea said you can't do that. So they have actually legislated a very good outcome. Now, in Japan, they've passed a mechanism that ensures what they call fairness and transparency, so that the digital platforms have got to explain to people what's going on. They've got to give them certain choices. It really fits within the way the Japanese law works. The Japanese law has provisions, for example, such as abuse of an unfair bargaining position. That's actually word for word a law they have in their competition code. So that law around fairness and transparency is, in a sense, just the beginning, but it opens up people's ability to know what's going on, both consumers and businesses, and to do something about it. So I think the issue with these sorts of laws is the Japanese and Koreans, they have passed them. They're law of the land. At the moment, the platforms are trying to quarantine so that they don't spill over to the rest of the world. But of course, if Korea has said you can't insist on, Apple can't insist on everybody using Apple Pay for all their payments, then I think that will spread all around the world. And so I think it's an extremely important development. So whereas you've got where you're up to in Germany, UK, EC, Korea's actually passed a law, as has Japan, which actually makes a difference right now.
Yeah. This is extremely interesting, Rod, because if we finally try to take a little look into the future and what is needed, we see lots of legislative initiatives around the world. There is a lot going on in the United States. Of course, for me, it is still quite unclear how high the chances of all these legislators are really to pass through. In Germany, we're a bit more advanced. The DMA of the European Union is on the way. We will start the trilogue by January between Parliament, the Commission, and the Council. The DMA is very much focused on ex ante rules. Let's put it this way, because we're wondering if it's competition law or if it's regulation, but there's supposed to be a lot of ex ante rules. Maybe we here in Germany are already a bit more advanced because our law came into force by January. We take a two-step approach. We have to designate companies which are of paramount significance for competition across markets. And once we have designated these companies to be of that nature, we can impose certain do's and don'ts. We can impose a certain conduct. We can prohibit self-preferencing, all these kind of issues that are in our law. So if we've seen what is going on in Korea and Japan, so if you look at all these initiatives, maybe also here the UK with the Digital Markets Unit, do you think this is sufficient, what we are doing? Do you think this is what we needed? Because if I talk to companies here in my office, what I often hear, I ask them, does the DMA help you? Does Section 19A help you? And they say, well, we don't know yet. And they say, well, Andreas, you must be very clear. We live in a world where the announcement of one of these companies to change the algorithm only slightly can drive competitors into ruin, into insolvency, because all of a sudden, because of that change, that minor little change of an algorithm, the business model of a competitor might not work anymore, all of a sudden. And what's even worse sometimes, these companies don't even have to change the algorithm. They have just to give a hint that they might change the algorithm, and you don't find an investor anymore for your business model. So this is why we are also discussing about kind of a algorithm pre-check, something like this. So what your idea for the future? What do we really need? Is that enough, what we do with the DMA, Section 19A, what is happening in Australia? Or do we need maybe even a much tougher regulation on algorithms to really make a difference and to make really sure that competitors or new entrants don't depend on these companies anymore?
I'm optimistic, Andreas, that we will get where we need to be. And I think it may well involve some look at the algorithms, but I think I'm confident that we'll get there, firstly, because I think there is this recognition around the world that the traditional tools won't solve the problem. Having sat in on ICN and OECD meetings, I'm convinced we're all of that view. So that's an important, we shouldn't understate that step. That's a really important step. I think the other thing we're gradually realizing is that this huge bias that's been in the system saying, whatever you do, don't over-enforce, much better to under-enforce. I think we're realizing that's not right either. I mean, John Maynard Keynes invented the term animal spirits, and they are very hard to suppress, Andreas. So I think making sure that we're strong enforcers is also now well recognized. Putting those two together means that, and of course, with the engagement of governments who've passed the law in Germany, and yes, you absolutely were the first to put in a comprehensive pro-competitive approach in Germany. But I think that will increasingly be taken up. I think it's important, though, we don't treat them as utilities and entrench their market power. It's important what we do is open up what they're doing to competition so that we get more innovation. We don't entrench them. They're not permanent monopolies. We want a pro-competitive approach. But I think, I guess our bias in Australia is a little bit more to the more flexible CMA approach. But of course, you've got the CMA approach, you've got the EC approach. Germany is ahead of everybody. You've got what's happening out here in Asia. We're all talking to each other. We're all watching. I think just we shouldn't despair that we haven't solved it all in one go. If you think about where everybody's mindset is now, because I've been attending OECD and ICN meetings for a long time, the consensus is now completely strong, whereas it was not 2 or 3 years ago. The understanding of the importance of these markets is strong. So I think we will keep moving forward until we get the solution we need. And not only will consumers bring us there, Governments are growing their understanding. As you say, there's competitors who want to provide competitive services. They are an important source of information as well. What do they need to unlock competition? As I've heard you ask before, it's an extremely important question. They come and see us all the time, as I'm sure they do you. So I just don't, we shouldn't despair. We don't have all the answers now. We have come a long way, and in 2 or 3 years, we will be in a vastly different position than we are now. So I'm very confident we're on the right track to open up these markets to competition. And if I could just put it this way, Andreas, it's like traveling down a road and you're in a traffic jam. You've only got to lose 5% of the traffic and that it opens up, right? You've only got to unlock these things a little bit, and you'd be surprised the extra innovation, the extra competition you get. So it's not as if you've got to solve every problem in the ad tech market and the apps market. No, just open them up a bit. Just let people glimpse in and give people a chance, and those companies will take that chance. So I think we're on the right track. I think it's a journey of a few more years, but I'm convinced we're going to go in the right direction, and we will get more competition over the next 2 or 3 years.
I couldn't have put it more confident with regard to the future. I couldn't have put it better, Rod. Many, many thanks. You know, this format is supposed to be fast and furious. I hope that was fast and furious enough. Many thanks. I share your views, especially on the future. I think we are on the right track, and I think we have a clear task and a very high responsibility for the future to make these markets really work better and to really take care that consumers benefit more from this fantastic invention and this fantastic development. We've come to the end of our time, Rod. I could go on with you for another 45 minutes, clearly.
I think we could go on for another few hours, Andreas.
Yeah, maybe.
We'd probably lose the audience, I think.
But as I said, this is the fastest format that the ICN has. So many, many thanks to you, Rod. I wish you a great day. It's an important day, and I wish you all the best, and hope to see you soon. I say goodbye to everyone who has been with us this morning, over the day, tonight. Take care, please stay safe, and well, see you soon. Many thanks and goodbye.
One quick comment, Andreas, just to thank you for your leadership on this issue. I've heard you talk about these issues over many years, and I think the ICN is where it is because of the leadership you've shown on these issues and the clarity of vision you've had. So I think the ICN's got a big role to play, and I thank you for everything you've done to get it into that position. So thank you.
Many thanks, Rod. Many, many thanks. Well, we try our best. Okay. Thank you very much, and see you soon, everyone. Goodbye.
Bye all.
Bye.